Mr. Luetkemeyer.
Thank you, Mr. Chair. It's interesting that we're discussing this rule today because I know the chairman and I fought this battle a couple, 3 years ago whenever the various powers that be tried to do the same thing with take the word navigable out of the Clean Water Act here. And here we are again today back in the same situation. And so I know Mr. Busby, with his comments, indicated that we've had the Clean Water Act basically in force and with the EPA the authority to make rules for over 30 years. And I think we've seen probably some good things come out of that from the standpoint we have much better clean water today. But as we see over the last number of years, bureaucracy tends to expand its limits, expand its authority. And it seems that we're in this process now. If you look at what's going on with the administration, there's where the biggest fear, why we're looking at this rule in this light, is there's this tremendous fear of overreach. And I think that the gentleman from Oregon and the gentleman from New York behind me here both were very articulate in explaining the concerns that they have, the amount of overreach here from the standpoint that there is this fear that it continues to be that this administration will overreach bureaucratically. Every time there's a rule or regulation, it goes one step beyond what their intent is, and therefore it impacts our business community in a very negative way. And I appreciate all of you being here today. I think, if this rule goes forward, I see no way that it doesn't wind up in the Supreme Court, because this is something that's going to impact all of the business people before us today in a way that's going to drive you either, to have extreme amount of costs or drive you completely out of business. And so I guess my question to each one of the three of you to begin with is, Mr. Field, if this thing goes forward, are you going to be able to stay in business?
I honestly don't know. It would depend on whether or not EPA would determine the parcels that I graze to be within their jurisdiction or not. And that, I can't honestly answer that. I'm sorry.
Mr. Parks.
Well, the question may be, at what cost will we stay in business? I mean, there are limits. I mean, assuming that the cost increases can be supported, perhaps, but who's to know? I mean, there's a limit on what we can absorb. What it will definitely do is reduce the amount of resources that we can recover, and will make permitting a much more complicated endeavor. And as a small company, we try to manage as much as that in-house as possible. We try to avoid going to consultants because that's a cost that we can't afford to bear because that's a trade-off.
Mr. Woods, I think you've kind of already answered that before, but you want to get on record one more time, get one more hammer at this?
I would, if you don't mind. Quite frankly, I would.
Punch your button, please.
Oh, I'm sorry. Quite frankly, I doubt that we'd stay in business, and I doubt that most builders and small developers would stay in business. You have to remember one thing. The costs that are incurred are before you can do anything. So there's not a return until you get the delineation of whether you're involved or not involved. And that doesn't mean that your plan's going to be accepted.
There's a huge capital outlay here before you ever get 1 cent of return on your investment, and it all has to be recovered at some point, hopefully, from the sale of your property and other homes.
And I think we don't understand small business. For the most part, small business is mom and pop. And it's mom and pop making a living for their family so that the kids can go to college. And if you've got a decision to make between spending $200,000 to see if you might be able to develop a small piece of ground and come up with a plan that might then 2, 3, 4, 5 years later get a permit, I can tell you the kids' college or the dental bill is going to win out.
One of the things that concerns me, it seems like this is a solution in search of a problem from the standpoint that what are we trying to solve here? Professor Busby, can you tell me what we are trying to solve by the expansion of this rule to go as far as these gentlemen think it's going to go? Where's the problem that we're solving when you impact jobs at this level that they're talking about here today?
I guess first, it's important to remember the Clean Water Act is not limitless in its reach, and so you do have to show that something is a tributary wetland, adjacent wetland, navigable water.
These gentlemen have all testified here today that they believe if they interpret this to the lengths at which you can go, at which attorneys will stretch the law, which has been the case time and time again, especially with this administration, this is where we're headed. So where's the problem that this is going to, this is trying to solve?
My sense here is that this is inaccurate, that people will be able to build, and people like Mr. Field will continue to have thriving cattle businesses. Not everything needs to be put in a tributary or a wash or a river or a wetland. There's plenty of land where businesses can thrive. The Clean Water Act is really about where you put these things and where you discharge pollutants.
Well, Professor, I appreciate you living in a utopian society. Unfortunately, these three gentlemen don't live there. They live in the real world, and they've explained how the impact of this is going to be in the real world, on real people, on real jobs and real livelihoods. And this is what this committee is all about today. Mr. Chairman, I yield back.